Ladies and gentlemen, welcome. I'm Benjamin Knotts. I'm the legislative liaison with Americans for Prosperity. Today, we are here to highlight the stories and experiences of those who are leading the fight against a policy that is threatening tens of millions of American dreams across the country. Innocently enough, it's called an ABC test, but this is not just a simple change to American labor law. These experts today are going to tell their stories and what they're doing to fight what they see is a painful change to our policies on labor. I'll be your moderator today. I'm hopeful that hearing these stories will inform you and motivate you to let your friends and family know what is happening in America today. From a bill is simply called AB5 to something that's called the PRO Act at Congress. This is a very important hearing today that I hope you will listen to, that I hope you will ask questions, and I hope you will engage on, because it could impact your very well-being and how you're pursuing your American dream. So without further ado, I want to introduce you to Karen Anderson. She's the founder and administrator of Freelancers Against AB5, comprised of 19,000 members, including independent contractors, small business owners, and anyone affected by the law. Karen, please introduce yourself and tell us what you're here for today.
Okay, my name is Karen Anderson. I'm a freelance writer, photographer, and managing editor, and I started the group right after AB5 the bill was signed into law in September of 2019. And I wanted to connect with other professionals to see how they were going to be impacted by this, what appeared to me to be a career-threatening law. And so within a month, hundreds and hundreds of stories started pouring in of people that were losing their livelihoods overnight. Everyone from cancer registrars and nurse practitioners to musicians, interpreters, translators, transcriptionists, writers, photographers, videographers, and every kind of independent contractor you could even imagine. And since the law went into effect in January of 2020, in my group alone, we have identified more than 600 categories of professions just within my group that have been impacted negatively by AB5 in some form or fashion. Now, when AB5 first went into effect, there was a handful of exemptions for people who had people like doctors and lawyers and veterinarians. And then a lot of contractors were just left out in the cold for 9 months until this cleanup bill happened in September and later that year. Now I want to address the myth that these professions are actually really truly exempted. There's a lot of fine print and caveat within these exemptions, and Lizelle, our employment law attorney, is going to talk about how all the many hurdles and poison pills in the law that make it very, very difficult. Just because your profession is named in an exemption does not mean that you can take advantage of that exemption. You might be named in a category that has a carve out in it, but you have to jump through 11 or 12 or 13 hoops to be able to even meet that exemption. Now, Jo Beth McDaniel, she's a part of the American Society of Journalists and Authors, and she's going to be joining us, and she's going to talk about why the lawsuit on behalf of journalists and photographers, press photographers, is still continuing because there's still restrictions on their work. One of the reasons that AB5 has such a chilling effect on the business community in California all across the board is because of the massive, massive fines and penalties that you can incur as a small business owner or even as a mom and pop or single owner business person for misclassifying something as simple as a videographer that you used on occasion throughout the year. It can put you out of business. So with that, I'm going to turn it over to Kevin Kiley, who has been a leader in the movement to repeal AB5 in the legislature, and he wrote a book just recently, and he calls AB5 California's cruelest law, and that is exactly what it is.
And Assemblyman Kiley, just so our viewers are aware of who you are. You're the state assembly member representing the 6th Assembly District, leader of this movement to repeal AB 5 in California, acting as their own attorneys. He and fellow California legislator James Gallagher, they won a lawsuit against Governor Gavin Newsom with the California Superior Court ruling that the governor abused his emergency powers during the pandemic. So, Assemblyman, with from your perspective, and just for those who are watching, what is this ABC test with AB 5? Explain it to them in the simplest terms possible. And what is the legislation like AB 5 or the PRO Act? Why does it even exist? Who is behind it? What are they trying to achieve?
Yeah, well, I mean, what they're trying to achieve is to advance the monetary interests of the most powerful special interest groups at the California Capitol, for sure, and in many capitals throughout the country. You say I'm the leader of the movement to repeal the law. It's actually Karen and many people like her who are the leaders of this movement, and they've built something that was really, I think, unique to our state, is having such a diverse movement of people from just an astounding diversity of professions and walks of life and political affiliations come together to fight back against an act of corruption that had completely uprooted their lives in many cases. So, in response to your question, the origins of this actually come from 2018, I believe it was. There was a California Supreme Court decision known as the Dynamics decision, which initially introduced this so-called ABC test, which supplanted the old standard for who's an employee versus an independent contractor, made it extremely difficult to be considered an independent contractor in most cases. And the proponents of AB 5, once the backlash really started, would sort of point to this Dynamics decision as a way to get themselves off the hook. Like, well, the court made us do it. The Supreme Court agrees with us. This is the right thing. It was totally bogus because the Dynamics decision, in the court's own words, only applied to one specific context, and that was wage orders, which are sort of like regulations issued from a state agency in California. That agency is now defunct, by the way. And the court in that specific case was tasked with interpreting this definition of employment in this wage order that was very archaic, that had never been interpreted by any court. It's this so-called suffer or permit to work standard that was actually originally formulated in the context of child labor. So the court, actually, the Supreme Court, I believe I remember correctly, the lower court had come up with something even broader than the ABC test to interpret this. And the California Supreme Court landed on this ABC test as sort of the best way to interpret this incredibly broad language in this obscure, antiquated wage order. And so, of course, the proper response on the part of our legislature would have been to say, well, I guess this isn't going to work. We're going to need to pass something to change the language of the wage order. In fact, that's what the Supreme Court said in its decision. It said, of course, the legislature can supersede the wage order if it wants to. And I actually introduced legislation to do precisely that in 2019, but the legislature went in precisely the opposite direction. They took the ABC test from the one specific context that the court had placed it in wage orders and placed it at the center of California labor law. And so when this passed in 2019, it was really in the fall of 2019, it was within a matter of weeks before the law even took effect that the consequences started cascading across various professions throughout the state. I think among the first to be hit were the writers for a sports site. What was it? Sports Fan Nation or something along those lines. It's owned by Vox, where hundreds of their writers were just let go. And then it just kept piling up and piling up. And so, long story short, we fought to repeal this all of 2020. We were not successful. The hold of labor on the members of the legislature who were for this was simply that strong. And then when the COVID-19 shutdown began, we tried again, saying, I mean, if you tried to invent a law that was sort of maximally incompatible with a statewide lockdown, like AB 5 would be pretty hard to beat. I mean, we were telling people you're not allowed to work outside your home, but then AB 5 made it impossible for a lot of people to work inside their home because a lot of freelance jobs is just the sort of thing you can do.
So let me ask you this. So In this conversation nationally about the PRO Act and them adopting something like AB5, which this ABC test, like for the average person who's an independent contractor of some sort, a freelancer, they work as a musician for a wedding, they do odd jobs at people's houses. And they do that kind of thing regularly. Like, what does this bill do to them? Like, what is it? What's, from their argument, they say, what's so bad if an independent contractor becomes an employee? What's that mean to a business?
Well, so in terms of kind of who the law ensnares, the really hard part of the test is the B, which basically suggests that, if you're doing something of the same kind of work as the entity you're partnering with, and then you're considered an employee. And with that comes, the loss of flexibility over when you work, under what circumstances, what your hours are, and everything like that. And so, various surveys have showed the vast majority of independent contractors willfully choose that status precisely because they desire that flexibility. They make the trade-off with eyes wide open of maybe giving up some of the entitlements that you're afforded as an employee, but then gaining the flexibility. And, when we documented all these stories and the stories Karen has collected, people give several examples of why it is they desire this flexibility. Maybe they're a single parent, and so they need to work around that. Maybe they have health challenges. Maybe they have mental health challenges. And so they're not, as well suited to the traditional 8-hour workday, and various other factors. And what laws like AB5 do is it makes it impossible to sort of blend your work and your life in that manner as you desire.
Well, thank you for sharing. I want to move on to Tom Manzo. He's the CEO of California Business and the Industrial Alliance, a trade organization that is fighting draconian labor laws in California, including the Private Attorney General's Act. Tom, coming out of a pandemic, many Americans feel uneasy about the road to economic recovery. What impact will an ABC test like AB5 nationally or the PRO Act mean for average business owners? Like, what does it mean for those who are suffering now in California? And what does it mean, particularly in the context of a pandemic?
Well, first off, I appreciate being a part of this today. And it's important that people are aware of the things that are happening in California, and what we're doing doesn't necessarily get exported to the rest of the United States. And I think that's the biggest takeaway we need to take away from this event today. People that are not familiar with the Private Attorney General Act, what that is, it's a law that allows an employee to step in the shoes of the Attorney General, and they can enforce any labor law violation that's made. And the Labor Law Digest here is about 1,100 pages. So people are getting sued over things like late lunches, any lunch past 5 hours. They get in trouble for miscalculating a bonus, not having an employee ID correct. Anything wrong on the paycheck stub ends up leading to one of these types of lawsuits. And there's probably 7,000 of these notices that go out every year. We've recently conducted a study on the effect that PAGA has, and it's really not helping the employee at all, who it was supposed to protect. It's not helping the employer. It's costing them twice as much money, and it's taking twice as long to recover the penalties. I mean, to settle the case. What we did note in our report was with AB5, we're going to see a huge increase in the amount of these types of lawsuits. So how does this all play into what's going on nationally? Well, right now, the state of Washington is seriously considering a PAGA-like law. New York is, Vermont is, Oregon is. So you have other states that want to duplicate this law. You take an independent contractor and you bundle what they're doing wrong into this particular law. And as we noted in our study, over the last 5 years, the cases have not necessarily went up, but they've increased sixfold. So 6 times that they've went up. I would project that once AB5 and lawyers start tackling these kind of claims because they're saying that this person should be an employee and not an independent contractor, you're going to see thousands and thousands more of these type of lawsuits. And these cases are going to be very, very expensive because misclassifying an employee in the state of California is a very expensive venture. And we've been opposing a lot of things that have been happening in California when it comes to labor laws. And, Lorena Gonzalez sent out a vulgar tweet about Elon Musk, and we decided to run an ad in the San Diego Tribune, a full page ad. And we said, hey, Elon Musk created a whole bunch of jobs, and right now your AB5 is going to be taking away a whole bunch of jobs. Who's really creating problems here for California? And after we ran that ad, we got tons and tons of calls from independent contractors. And to be quite frank, I think I'm pretty familiar with a lot of the labor laws and things that are happening here in California. I didn't realize there were that many independent contractors. 400 at the time. I talked to Karen yesterday, and she said that there's close to 600 different types of independent contractors. We had people calling us up that were translators, and they were translators for the U.S. Army, for the military that would be and stationed in Iraq or Afghanistan. We got calls from people that had good jobs that were doing reporting and putting things together for people. And all of a sudden, out-of-state companies said, we don't want to get involved with this. We don't want to have to, end up in a lawsuit because of this crazy California law. So people who were independent contractors who were relying on revenue, all of a sudden lost the revenue. And people here, business owners, the business community, they're afraid to hire an independent contractor. And I can tell you a couple of big reasons why. One is last year, the state was in a deficit. We're in a pandemic. COVID's going on. But Newsom somehow figured out in his budget, we're going to have $20 million to go enforce AB5. I mean, that's insanity. I mean, that's the last thing we should have been focused on at the time. But that's the case.
And I want to go back to what you just said a second ago, because I think, again, if you're just joining us, we're talking through the personal experiences that we're seeing of people dealing with ABC test bill AB5 in California. You said that, people lost their revenue. Explain that. That's people losing their jobs, right? People are losing opportunities.
Pretty much.
So
and to go back. So what people are being told and how this law is being enforced in California is the first thing that they're doing. The state is saying, I want to review all of the 1099s. And if they're reviewing these 1099s and somebody smells like an independent contractor, they're going to pursue that avenue. So a lot of the business owners are aware of this. So instead of having an independent contractor, say I have somebody that's doing some type of reporting, they're doing studies for me. Maybe they're an event planner. Maybe they're doing weddings for me, but my company's based in Arizona or I'm based in Colorado, but I'm utilizing talent in California because sometimes some of these things are happening in California. I'm not going to use them anymore because I don't want to take the chance of being sued over the independent contractor. And a lot of folks that I've been talking to, that's what happened. Some of their work is actually dried up because employers are afraid to engage with independent contractors.
Tom, I appreciate you going into detail there, and stick around for the Q&A. I appreciate you. Now we're going to move to Lizelle Brandt, and she's a business and entertainment attorney in Los Angeles, specializing in AB5 and its impact on businesses and independent contractors. Lizelle, a lot of lawmakers that support these sort of reclassification bills like AB5 and the PRO Act, they say reclassification criteria protects businesses, workers, and opportunities. And they also say, and some of the people in the industry think they can be exempted from these laws and everything will be fine. It might be bad for this guy, but they'll be okay. Could you just answer some of those thoughts and give your perspective on it?
Sure. Thanks again for having me here on this wonderful panel. And I actually think it's perfect that the person preceding me was Tom Manzo, who talked about the PAGA Act. So from my perspective, as an attorney who deals with small businesses and a lot of moving parts in the entertainment industry, often what businesses will do is they'll come up to me and they'll say, and this has happened pretty frequently this past year, over year and above that, is that they want to know, well, can I pass this test? Is this something where, if you're an independent contractor, can I be hired? Or on the flip side, if you're a business owner, can I hire this individual? And when I go through the analysis as a lawyer for small businesses, what I have to do is say, well, this is what you have to look at. And we start out with, are you part of the great class of people that are exempt to go straight to Borello, like for instance lawyers? If not, if you're not specifically identified, then we're got to go through all of the different exemptions, and within those exemptions there's a lot of different poison pills, as Karen Anderson had mentioned. I could just go through a few of them right now. For instance, you've got the business to business exception, which is something that businesses will commonly turn to. Do I qualify under here? The problem with that is that you have to meet a bunch of different prongs in order to even go to Borello. And one of those issues is whether or not you are providing services directly to the customer. I'll give you an example. If you're a photographer that is at a venue like a restaurant that regularly, say, photographs the restaurant patrons, and you want to, as a business owner, subcontract out 1099 another photographer to help you out. Now the issue is that, well, that photographer is doing the same line of business as you, and who are they providing services for if they're taking pictures? It is to the customer. It is, whether you want to call it the restaurant or the people that they're taking pictures of. But you can see how very easily you won't be able to pass the business to business exception. We can go on to the referral agency exemption, which is another exemption that has been put forth that you might be able to pass. The issue with that is that you can't use the company's name. So what I'm seeing is I have some clients that are tutoring services companies, and they want to hire tutors from all across the country to help students. Now, the question is, would they be okay with those tutors going out and saying, okay, I am tutoring on behalf of myself, not on behalf of the company? And the answer is generally no. So that in and of itself prevents a lot of independent contractors from being hired under the referral agency exception. And what I'm seeing, similar to what Tom Manzo had mentioned, is that when I go through the analysis with the client, how do you deal with this is, well, do they want to have these virtual tutors, which is happening in the pandemic, now come from California? What if they exclusively just hire these virtual tutors from outside of California to deal with that? So you're seeing, businesses are pivoting to the harm of a lot of people in California, actually.
Well, I got to pause you there, because you're saying that tutors, in where we're having an education crisis right now because schools have been shut down and parents are looking for supplemental means to educate their children. They're increasing access to sources of education and increasing the costs of accessing that education. Is that an overstatement?
If you want to call it that, yes. But what I'm saying, that again, I look at it from the perspective of the business owner, the small business owner that is hiring these tutors. And practically speaking, what are they going to do? If you're looking at, well, if I hire them as an independent contractor and I 1099 them, and practically speaking, at the end of the day, if they're from California, am I going to have to deal with a PAGA claim? Am I going to have to deal with misclassification claims when, as they've mentioned, you've got $20 million in the enforcement arm of this? Well, what about the fines? What about the workers' compensation issue at the end of it? And when you add all of that up, it doesn't make business sense to then hire this person from California. And so what, again, I'm seeing is that sometimes the business decision is made that, well, then let's stay away from people in California. On the flip side, the other thing is, well, let's reduce the workforce then, because it has to come from somewhere. If you're not reducing the number, I've got a dance studio client, and rather than have 6 dance instructors, let's bring it down to 3 people, because you've got only a certain amount of budget as you increase all of these additional, unemployment insurance, everything, the payroll tax, everything that you have to add on that you didn't have as overhead before. And it has to come out of somewhere. Either you're going to pass on the cost to the customers, or you're going to take it out from your services, your inventory, in which case, in this case, is the workers. So the people that are being harmed are the workers. And as a lawyer, when I go through these analysis, I have issues with just looking at these codes. There's issues of vagueness, like you've got the professional services exemption, and is that really going to protect journalists when you have issues about, well, you're not allowed to directly replace another journalist? What does that mean? Because it's not completely defined. How far back can you go? Another thing is the issue of like the fine artists. So they, in the AB 2257, they at least updated the language. I still have an issue. I can't even tell my dance studio client whether they qualify as mixed media because it's not defined. And again, when you look at it from a lawyer's perspective and in a risk analysis situation, the issue is, well, do you want to take that risk, given that later on you could get, I mean, there's a list, the PAGA claims, the misclassification fines, the workers' compensation fines, everything that adds up a lawsuit. So in the end, is it worth it? What I think this is doing is it's just crippling a lot of businesses. They're either downsizing or they're moving out of state.
And so for, somebody that's just trying to understand this, because I mean, there's so many different industries that are impacted. There's so many different unintended consequences. I mean, so many different industries. I mean, so many different opportunities. To boil it down, it basically sounds like they've just made it too risky and too threatening to hire people. Is that essentially what businesses are having to deal with?
Yeah, I mean, I haven't even mentioned the entertainment industry. I do a lot of work in that industry. I've got clients that are small independent filmmakers. A lot of what they've done before is they've been able to rely on hiring, just for a couple of days shoot. Sometimes it's a couple of days, sometimes it's a week. Do you need to bring every one of these individuals on payroll? And if that doesn't make sense to them, well, maybe we go out of state to Arkansas. Maybe we go to Georgia. Why, you call California, I'm in Southern California, you call this Hollywood, but what are they doing to Hollywood? They appear to be just like, okay, get out. They don't care. And this is going to cripple a lot of, again, independent filmmaking, because to make all these requirements is just going to make it tougher. It's just going to, I mean, I would say a lot of states around the country are probably thanking us for a lot of the business that is leaving as a result.
Well, thank you, Lizelle. For those just joining, we're talking through how AB 5 has negatively impacted California through this ABC test, and how this applies to the PRO Act, which is a national effort to implement this nationally. We appreciate you, Lizelle, speaking from the business and entertainment industry. We want to move on to, and please post your questions. We're going to be getting to those in just a moment. Also, we have Jo Beth McDaniel. She works with a freelance journalist and author in California, and she's a plaintiff in the continuing lawsuit against AB 5 filed by the American Society of Journalists and Authors in conjunction with the National Press Photographers Association. Jo Beth, in California, there's a lot going on, especially with freelancers. I've heard from a lot of journalists, and they were some of the first, I think, to speak up on this. What are you seeing there? And could you just explain, how this is impacting you?
Sure. Thank you so much. And I'm happy to be invited here. We first, AB 5 first kind of came on our radar at ASJA back in 2018. And we had all these writers groups come and try to fight it. And some of the writers groups decided not to fight it. Now, they were based in New York, and I think they were maybe getting some bad information and were confused. We talked with a lot of lawyers. In fact, I had one lawyer come give a presentation, and he explained how intellectual property is in danger, basically, with AB 5. This was before it passed, because let's say you are a writer and you write a nonfiction book. You sell it by proposal. So the company that hires you, they pick up your book and have you write this book. They pay you for this book. That could be construed with some of the things in AB 5 that you are an employee. The problem with that is copyright, of course. And this is the same thing with journalism as well. Independent contractors hold on to our own copyright. Employees do not own their copyright. So we were very much against this law from the start. We tried to work with the legislators. They didn't listen. Even legislators we had worked with prior, it was pretty shocking, actually. So once it passed, we interviewed a lot of lawyers. We launched our lawsuit at the end of 2019, before AB 5 took effect. I'm one of the key plaintiffs. in this, discussed how I'm a First Amendment Committee chairperson for ASJA. AB5 said grant writers and marketing writers were exempt, kind of exempt. They still lost work. But journalists, they had all these restrictions on us. Now, as Karen mentioned, in September of 2020, AB 2257 passed, which was supposedly the fix-it bill for AB5. And a lot of people took that to mean, oh, AB5's gone, or AB5 doesn't affect journalists anymore. We have this huge section where, for example, replacing an employee is forbidden. And so, for example, I had an editor who had someone on staff who had a huge health issue. They weren't sure if this editor was going to be able to return to work. That editor reached out to me, and I knew that that publication could get hit with fines that start at $5,000 per incident per person if they decided that I had replaced this staffer, who eventually was able to come back, but 6 months later on a part-time basis. So I had to say no to that and tried to help this person find some writers outside of California. The other thing is that journalists are not allowed to do video reporting for television, film, or theater. That is specified in AB 2257, which is the fix-it bill to AB5. So what that means is if I were out covering a wildfire, for example, and of course, everybody's got a cell phone, taking a video of the cell phone. If I sold that video, even a 10-second wildfire video, to a television station, that television station could be fined $5,000. Now, just for comparison's sake, if I sold meth, if I went out there and sold meth on the street or some illegal drug, the fine would be $1,000. So that's the minimum.
Oh, wait, I gotta go back to that. So you just say that again. So if you sold a video to a news company, so they could breaking news, you're there on they could say, oh, they're an employee, and they could be sued because you chose to profit off a video that you took, that they want that. It's I mean, really.
And so much of journalism is moving to multimedia, which includes television, which includes audio.
But what does that do for independent journalists that are just coming up? They want to be independent bloggers, and they want to make. What does it do for them? Are they able to like climb that that ladder if they can't offer some of their services like that?
I would say that right now, not everyone in California understands the letter of the law, and so a lot still happens. But I began my freelancing when I was a teenager in college, and I worked for 4 different publications while I was a teenager, for money. I was a paid journalist. And it's just heartbreaking that these students are not going to have those opportunities to build their careers. And yes, everything is multimedia now. So the other thing I wanted to add is, because journalists have gotten a lot of attention on this, but freelancers are about 1/3 of the entire US workforce. And that's if you count full-time and part-time. A lot of people in our coalition are union members. I'm actually an inactive union member. I taught college journalism, and the first thing I did was join a union. I was thrilled. And then I didn't realize at the time how much unions had affected the college academia. That part-time W-2 employees for the state of California, public universities, are some of the most abused employees out there. About 40% on our own government benefits. And this was a direct result of unions saying, we will back the professors with tenure and not these adjunct professors, who are now 70% of the college professor workforce. So, I know that going part-time W-2 is kind of the worst of both worlds. That state college required me to have computer system, Wi-Fi, a cell phone, all this equipment that I had to have to do my job. They didn't pay any of that, and I couldn't deduct it. They weren't business expenses because they're W-2. It's a W-2 job, not a 1099 contract. If I had been doing it on a 1099 contract, I could have deducted those, essential business. So when we talk about AB5 and the ABC test, forcing people into these usually part-time W-2 jobs, those are the worst of the bunch. You don't get benefits. You don't get good pay. You're not able to have the kind of flexibility and control over your own life that you do as a freelancer.
And I think it's important to kind of reemphasize that that opposing these ABC tests that are being pushed in things like AB5 or the PRO Act, we're really protecting worker choice, protecting worker opportunity, and protecting that freelance spirit that lets people go out and define and fight for their own American dream. And so I appreciate you sharing that, particularly with that inspiring story of you starting out and how sad it is that some people will be denied that same opportunity. Very cool. Thank you, Miss Jo Beth. We appreciate you. We did have one more panelist today, Damon Dunn. He jumped off, but he did leave his comments, and I wanted to make sure we could read him, but read his comments that he shared and I wanted to read those just briefly before I throw it back to Karen. But he said, here we go. Now, Damon is a franchisee for Dunkin' Donuts. He said, I value being an independent contractor. Employees are paid through W-2. That means the government collects your taxes at each pay period. I value managing my free cash flow and pay my tax at the end of the year as an independent contractor. I can expense travel, meals, home office, and other business expenses. Employees are not self-employed and do not have expense options. Ultimately, the franchisor will elongate franchisees and just hire staff to open and manage new stores. If they take all the risk, then they want all of the benefit. Currently, franchisees are making $150,000 to $250,000 of NOI per store. And now that franchisees will become an employee, they'll only make $50,000 per year. And this will impact the middle income and lower income franchisees because they don't have access to capital. That the franchise model creates bank relationships to finance those openings. Also, the training and operations oversight helps people who do not have deep operating experience. He said that will ensure that the wealthy, experienced, and well-connected will have an advantage over those just starting out. He said, but people that want to be in business for themselves, but not by themselves, have support to finance, operate, and manage your business. So his point that he wanted to make is that if you are a franchiser and you're looking to own a franchise, that's your American dream, that you could go from earning $150,000 a year through a franchise and be demoted effectively to $50,000 a year and not have the influence or clout to make it work. So countless Americans look to a franchise and buy in a business like that to earn a living and to empower themselves. So I'm glad Damon was here to share his experience and how this threatens his American dream and how it's threatening the American dream of millions of Americans, especially if the PRO Act is passed, which is another ABC test like that was passed in AB5 in California. Karen, we've talked through a lot here. I want to see if you see any gaps that you'd like to fill, and we've got some questions we want to fill. And make sure if you have questions, post them in the comments. And if you have them specifically to our panel, please put that in the question. So, Karen?
Yes, I'd like to address audits. This is the dirty little secret of AB5. The law deputizes all of these government enforcers to go after any business, large or small. These government enforcers include the Attorney General, city attorneys, and now in the new cleanup bill, they added district attorneys in any city, in any town, and they can go after any business, large and small. So I'm the one that gets the phone calls from these small business owners and sometimes one-person business owners, moms and pops who are under audit right now for these very trivial misclassification violations of, say, having having a videographer for 6 months off and on, or one gal had a platform that connected referees and umpires to schools. She was under audit. We have just these horror stories, and the penalties and fines are just massive. Jo Beth mentioned $5,000. That's the low end. The fines for misclassification, the civil fines for misclassification are between $5,000 and $25,000 per violation. And that also includes back pay, back taxes, and all of those back benefits that an employee would have been entitled to had they not been quote unquote misclassified. And I think Lizelle can really dive into just how onerous and draconian and chilling this is on the business community. And it's why, and it's also retroactive by 3 years. And it's why these businesses are not, even if you have an exemption, even if you're completely exempt from the law, well, there's actually graphic designers were exempt in the original AB5 that went into effect in January of 2020, but they still had 6 or 7 prongs that they had to meet anyways. But be that as it may, we have graphic designers in our group that lost clients anyway. People that are actually exempt from the law are losing clients regardless, because businesses don't want to touch California contractors at all because we're radioactive. And I think that Lizelle can address some of those back taxes, back penalties, and the retroactivity of AB5.
Yes. So again, the penalties, that's pretty much where I start off with. Like when I talk to a client about whether or not they should reclassify a worker, if they can bring somebody on and 1099 them, the first thing we have to look at is, well, what's going to happen if you potentially 1099 them and you're wrong because they're not clearly exempt. And as Karen mentioned, you're looking at the penalties, $5,000 to $25,000. You're looking at workers' comp penalties as well if you fail to have workers' comp insurance. That's an additional $10,000. You're looking at retroactivity. So this can go back as well. You've got the unpaid wages, the unpaid unemployment insurance. So you've got all of the penalties for having not paid also going back. And when you look at that, it is, as she had mentioned, it puts a chill on hiring independent contractors. People are scared. I represent primarily small businesses and companies, people in the entertainment industry, but I also have friends who I went to law school with that now run some of the biggest labor and employment law departments in California. And what I'm hearing is that generally they're telling their clients to just stay away, don't 1099 anybody, just W-2 everybody, because that really is just the broadest, safest advice to give if you want to minimize the risk. Otherwise, you are taking the risk. And when you take the risk, you're looking at these penalties. You're looking at it going back. You've got lawsuits. And these are just, so again, as Taryn had mentioned, it could be the district attorney. It could be just anybody that randomly calls into the district attorney. These lawsuits, they'll pop up from people that you've hired, from people that you haven't hired, because they're whistleblowing, or they're calling and saying, hey, I don't know if this is necessarily right. It might be from your competitors. So it's a pretty scary environment out there with how the law is structured because of how vague it is. And then again, all of these penalties that you have, and how it also goes back, which in itself, I would say that in itself could be a little bit clearer how far back and how retroactive it is. So when you look at it again from a risk analysis standpoint, the safest advice is to try to avoid that. Don't bother if you have to, because this could shut your business down. And I've seen it shut businesses down.
Hey, so the AB5, so the PRO Act is modeled after AB5, and it does impact a lot of the same groups. So, from your experience with that, like some people were under the impression, we got a question. They say, are music groups, stage actors, or musicians really considered contractors under the PRO Act or an ABC test? And that's the case, correct?
So I would say, unless there's a clear-cut exemption, I can't answer on a specific case-by-case basis without looking into more details of that. As far as the PRO Act, the test for the PRO Act, the issue with the PRO Act is it bills itself as an act to basically allow people to organize. But the issue is that it creates a definition of employee that matches the dynamics test and the ABC test. So the problem with that is when you look at around the country, if you make that the federal definition and you put that in and you codify that and you make that the definition of an employee, then now you can have courts across the highest, all across the country who are looking for definitions of employees, and hey, let's turn to this federal definition, which could be pretty persuasive, and let's go there, whether it's the legislatures or the courts, when they're looking to interpret things. So there is definitely I would say it's a lot wider in effect than it is billed out to be, because you're now creating a federal definition that matches with the California Dynamics ABC definition, which again is pretty hard to pass in and of itself. And in addition to that, they, unlike the exemptions that have been placed into AB5 and AB 2257, those don't currently exist in the current draft of the PRO Act. So a lot
all the things they're trying to fix, they would just be starting the opening the can of worms federally for all 50 states, correct?
Yes.
That is unfortunate. I've got a bunch of questions here. If y'all can feel free to say, to come off to come out from behind the camera. And if you think this is if you can unmute yourself and chime in if this is in particular that you find interest in. But one of them says, if you have an LLC or an S corp, but are the sole person working for your company, but you were subcontracted by another company with proper tax designation, are you still in danger of being misclassified? Karen, who would be best to answer that?
That would be Lizelle. But yes, I could actually field that question myself. Having an LLC or an S corp does not exempt anybody from AB5. It's just one of, I think, 13 prongs in the business-to-business exemption that you have to meet. And so people are under the assumption that an LLC will protect you or give you this get out of jail card. And even if you pass the business-to-business exemption, you still have to pass the traditional Borrello test that Lizelle mentioned, which has been in place since 1989. So you're not automatically going to be able to be an independent contractor.
Great, thank you. And so if the PRO Act was passed, the same would apply in the same context, correct?
Well, the PRO Act doesn't have any exemptions at all. And so what are we supposed to do? Does the rest of the nation want to see the catastrophe that have the same catastrophe unfold that we're still experiencing in California with this horrendous scorched earth exemption process where they burn down the village and they dole out exemptions to a chosen few and leave hundreds and hundreds of categories of professions out in the cold, and everybody's filing, pleading for their lives like orphans in an orphanage. And then you have lawsuits flying. There's the International Franchise Association has a lawsuit against AB5 now because they can't, a franchise business model cannot pass the ABC test, and the legislature refuses to exempt them. There's also the trucking lawsuit, the California Trucking Association. We're waiting to hear from the Ninth Circuit on whether they have a temporary reprieve against having AB5 enforced against independent owner operator truckers, but that is still, they are not out of the woods at all. And the court reporters have a lawsuit filed against AB5, and it's just the litigation is just going to continue to pour out, and the plaintiff's bar in California is just it's a field day for them. And I think Kevin Kiley, Assemblyman Kiley, can address that.
You'd think that after a year of this, I'd not make a mistake with the muting. So the exemption process has, yes, just been a total mess. And, there's now, what is it, Karen? It's like 120 exemptions that have been put in place. And there's no rhyme or reason to the ones that are there from any sort of principled point of view. It's all just been political, whichever groups have the most muscle inside the Capitol. And honestly, the exemptions have been wielded as weapons by the AB5 proponents as a way to sort of fracture opposition. So from the very beginning, they exempted these, really powerful interest groups that might have sort of strengthened the opposition coalition. And, as Karen said, even if you're quote unquote exempted, you still have to jump through all these hoops, and it still creates all these problems. And there's just a huge chilling effect because, as just the risk of litigation.
Assemblyman, I want you to say what you just said again, because I don't think this is the reality that I'll say as a lobbyist, I had a conversation with a key player, and they told me if this came to Virginia, a version of this came to Virginia, that they would just exempt themselves, and they really weren't worried about it. And so I want you to say what you said again, because there is an assumption that this is helping the little guy, the little independent contractor, the little independent business owner. And what you said is that the wealthy, well-connected are going to try and get out of this, but the little guy that can't afford a lobbyist is the one who's really going to be stuck. Is that what you said?
That's exactly right. And it's what shows the farce of the whole argument that this is somehow about worker protection, because those industries with sufficiently powerful lobbyists are just exempted from these protections entirely.
Thank you, Assemblyman. We had a couple questions here. I really want this one answered. So y'all are all going to probably make a face, but it is what it is. They said, didn't Proposition 22 help California solve this problem? Question mark.
I'll answer that. There is so much misinformation in the national media about Proposition 22. Proposition 22 did not repeal AB 5. It only exempted app-based rideshare and delivery only. It gave them a specific carve-out that also included some access to healthcare, stipends, and worker protection, and 120% minimum wage. And it's a sort of a third classification, which if we're going to save the gig economy or allow it to continue to thrive, you're going to have to make those kinds of concessions, because the binary decision of either employee or independent contractor is archaic. It's archaic. And I think that Tom Manzo can speak to just the chilling, well, he has, but Tom, what can you say about the fact that most of these PAGA lawsuits, for example, they're looking for a settlement. You can't even defend yourself in court or in a trial or in front of the labor commissioners. Isn't that correct?
Yeah, it is. And I could just tell you one thing. People that are considering this nationally, and this is something to really think about. And we work with the California Trucking Association, our organization. We're very familiar with their lawsuit. We got a call 2 weeks ago from a small business that hires college kids to help move people. And currently right now they're in a lawsuit because they're being accused of they had independent contractors and they should have been employees. There's no way these college kids could have, would have, should have been employees. It's so confusing. I don't even think a lot of legal people are they exempt? Or are they not exempt? I mean, yes, some of the trucking companies do have exemptions now. How long is it for? What are they actually hauling? What are they doing? But to just give you a little bit more insight on this, think about how much we rely on as a nation, trucking. How many are out there? And the business model has been for years and years. Independent truck drivers would make more money. They had their own hours. They enjoyed their own routes, and they did well. They're trying to completely tear this apart. And the reason is because as big labor, unions just want to unionize more and more employees. And they're doing this at the risk of really destroying the economy. I mean, AB 5 here is a total disaster. Prop 22 helped out a small certain amount of people. It's not doing anything for, the other 600 independent contractors that are out there.
this proves the assemblyman's point that only the well-connected can get exempted from it if they've got enough resources. I mean, how many small businesses are going to be able to afford doing a statewide campaign to get a resolution on the ballot to vote yes or no on something?
Yeah.
I have something to add to that as well, that we noticed, because of course journalists were trying to get an exemption, and we were told, "Go, who's your lobbyist?" Well, we're freelance journalists, and lobbyists are very expensive. So what we saw in the exemptions, doctors got exemptions, nurses did not, respiratory therapists did not, marriage and family therapists did not. You just go down the list. Lawyers got an exemption right away. Paralegals did not. Court reporters did not. Court translators, and I should have mentioned medical translators too, and interpreters. These are people like nurse anesthesiologists tend to serve our rural areas in California. It has absolutely affected our medical system here in California in a huge way. And that would happen with PROACT as well. You would see the male dominated, excuse me, but it's true, the doctors, the lawyers, but not the support not the nurses or the paralegals. You would see these very well-funded groups get their exemptions, and they're already working on it. We've seen proof of that. So it's definitely something to be concerned about.
I really think that last point's important. The last few elections in the United States, a lot of it is centered around healthcare and the cost of healthcare, making it more affordable and more accessible. And Assemblyman, you might be able to follow up with that. Is this raising the cost of healthcare and making it less accessible, making it harder to deliver care in the middle of a pandemic, and doing that nationally? Would it make it even worse?
Yeah, this is one of the points we raised right when the shutdowns went into effect. Is not only is this causing sort of a gratuitous loss of employment beyond that which is directly necessary from the shutdown, but also it was keeping many healthcare workers off the front lines. The categories that you just heard from Joe Beth, nurse practitioners, nurse anesthetists, even folks like the translators or elder aides. I wrote a letter to Governor Newsom in early March of last year pointing this out, and yet there was still no interest in even suspending the law.
That is frightening. We got another question. Will AB 5 PROACT affect real estate agents?
Well, I mean, the PROACT doesn't have any exemptions at all. Real estate agents have an exemption in AB 5, I think under the professional services category, if I'm not mistaken. They had a lobbyist, they lobbied hard for it. But real estate appraisers when the law first went into effect, they didn't have an exemption, and it was insane. And we had real estate appraisers in our group that lost their careers because of this stupid law.
Gosh.
And they're independent. They're supposed to be independent by their very nature. So they got caught up in the language, and it took 9 months for some of these people to get an exemption that they never should have. They never should have been a part of the law in the first place. And like musicians, for example, let's talk about them. There's this misconception that all musicians are exempt. Well, that's not true. Only a segment of musicians are exempt. Only a segment. In the beginning, when AB 5 first went into effect, if you had a little band that played at the local neighborhood bar, you as the band leader would have to make everybody your employee and put them on payroll, even somebody that sat in with you for a night. And so it was just ridiculous. So for 9 months, they waited for their exemption. And throughout all of this, the pandemic actually obscured all the BS that was going on with AB 5. But musicians, even the musicians now, these bar bands that got their exemptions, there's still restrictions on them. They can only play once a week at the same venue. Otherwise, they would have to be made an employee. So there's all this fine print that's going on, and all of this, devious little poison pills inserted throughout the law. And you really cannot say for certainty that anybody is safe.
I think there is a good point to point out that there's been a common thing here at the end of this, and it's that the wealthy are going to be okay in this in some way with lobbying, and a lot of people, but it's the middle class, lower middle class that aren't going to have access to lobbyists. They're good. The cost of services, for the cost of goods being, for truckers, the accessible healthcare, low cost healthcare, all these different things that the regular person's really going to feel in a tangible, painful way, is what we're talking about here. So, it means the world to me that y'all have been fighting this, and I want to give each of you a chance to kind of give a final statement on your experience with AB5, and tell America to avoid that at all costs with the PRO Act. And Karen, I'll let you open the final portion, and I'll let you close it.
Well, I just, the exemption process is not a solution to anything if the PRO Act passes and the ABC test becomes embedded or ensnared or entangled into federal law. And what we have also, in addition to the PRO Act, is other sister crazy labor laws that would be even worse than the PRO Act, that would insert the ABC test into the Fair Labor Standards Act, which would address wages and employment and things like that. That would actually be AB5 on steroids. And so the current administration has said, we want the ABC test in labor, employment, and tax laws. That is their goal, and that's what they want.
Assemblyman?
Yeah, I just say that, I think California provides a warning to the rest of the country about what happens when your politics are just completely corrupted and your capital is run by special interests. And, it's ordinary people who pay the price. And, it was John F. Kennedy who said the rights of man come not from the generosity of the state. And yet with AB5 and potentially with the PRO Act, you're flipping that on its head. And you're saying that in order to work, to pursue your livelihood, to pursue your calling, you need the permission of the government. So I would hope that everyone can band together at the federal government to heed California's warning and reject this.
Lizelle?
I would say that AB5 is a business crippler. It is a business killer. It also completely is a slap in the face of people and their workers' integrity, those who want to work as independent contractors versus those who want to be employed as employees. And I hope it doesn't go national with the PRO Act.
Tom?
Well, I like this opportunity because I'm going to say what I think a lot of people are afraid to say. And I think this is what makes our trade association a little bit more unique than everybody else. The issue is big labor. I call them big labor because unions are just as wealthy, if not wealthier, than large corporations. So there's about 85% of the business owners, operators, independent contractors in the United States who are non-unionized. So you have 15% of this population telling us all how we should live our lives, how we should employ our employees, how independent contractors should be paid. And it's not right. It's wrong. They should mind their own business and worry about their own employees before they start telling everybody else how we should treat and conduct our employees. And for our organization, our group, we're fed up with big labor telling everybody what to do. And this is exactly what's happening nationally now. You have big labor saying, hey, we're going to pass this law nationally. It would be a complete disaster if they did this. You would stall out all of the trucking, all of the commerce. It would be horrific. And the only reason they're trying to do this is they want to make the union bigger. They want to get more money in their coffers so they can continue to promote and push their own agenda. So that's my warning, is I think people need to start changing their voting at the polls. They need to think differently and say, if they're bringing in all of these pro-big labor people to tell us how we should be doing things, then I need to vote for somebody else next time.
Thank you, Tom. And Jo Beth?
Yes, thank you. I'm going to focus on the PRO Act because I've been attacked quite a bit because I'm vocal about it. And it's true that right now the House PRO Act bill is only affects a certain part of our. It's not employment law, and it's not. It's only about organizing, they say, but it's not really true. I mean, there are a lot of parts of it that are very dangerous. That we see exactly what happened with California AB 5. We saw it coming. We saw it railroaded through with zero research, zero debate. That was not allowed. And what's happened now, the Senate version of the PRO Act was introduced in February, more than a month ago. And the text of the Senate version, which Senator Patty Murray of Washington is the one who introduced it, the text is still blank. If you go onto the Senate.gov website, which I do on a regular basis, the text is still blank. Now, what that tells me is that there's a lot of sausage making going on back there. And I know that we've been talking with Senate staffers from California. We have American Society of Journalists and Authors is a national group. So we have people all over the country working on this. And we have Fight for Freelancers USA is the website.com, where, we've gathered all this information about the PRO Act. And we dispel a lot of these myths and a lot of these talking points that just are not true. Now, our opponents say that we're confused. I've been working on this since really the end of 2018. I've experienced this in my own life. I was not able to do a podcast project because the risk, I could have lost my house over it if the state decided to go after me. So I had to cancel it. And we know this issue on a personal level. Like Karen says, we hear these horror stories all the time. And we just wish that people would listen. The people in California, we've been dealing with this for so long now, for years. And we have read the PRO Act front and what's out there. We've read what the current administration says. We just want people to listen. We've seen this before. It's the exact same game plan to railroad this through with zero research, zero debate. And we're like these test subject mice that they're running through this maze, saying, oh, this is going to help you. It has not helped us in California at all. We keep begging for any research that shows that it had a positive effect. It's not there. So I just, please stay aware of what's going on with the PRO Act and let your elected officials know what you think about it.
Karen, any final words to your viewers out there?
Well, I would just say keep engaged and do your research. And if you want to read the horror stories that Jo Beth mentioned, come to Freelancers Against AB 5 and check them out. We have hundreds and hundreds and hundreds of stories that will break your heart from regular people just trying to care for their sick loved one, caregivers, stay-at-home moms caring for special needs people. Seniors are really getting hammered by AB 5. Entire sectors are being decimated in California, including the wedding industry and independent filmmaking, and community theater is another one. And it's been obscured by COVID, and it's been obscured by Uber and Lyft, but it's happening, and it's happening in real time, and it's continuing to unfold. It's not a past tense event. The disaster of it is continuing to unfold as we speak, and people's lives are being destroyed by this law.
Well, folks, we appreciate each and every one of you participating today. I'd like to finish it up here. I want to remind you that when she's talking about something that's really happening, real people, your favorite restaurant can't hire their favorite musician. Your favorite restaurant can't afford to hire another worker. Your favorite doctor is being hamstrung with the kind of people he can employ. In these real life examples, you see the pain that this poorly thought out policy is bringing, and that could be exported across our country. And that we have an opportunity in Virginia in particular with Senator Mark Warner, who is a champion of business and champion of Virginia's right to work laws and opportunity and entrepreneurship. And he is what we view as a possible vote that could put the end to this. So we're really hoping you will reach out to Senator Warner and connect with him your concerns and your opposition to the PRO Act, and listen to the stories, look them up, and just Google it. It's everywhere. This isn't something that's been manufactured. This is real. People's lives are at stake. People's communities are at stake. People's livelihoods are at stake. We hope you'll pay attention and get engaged on this issue. So thanks so much to each of our panelists today. I'm Ben Knotts, Legislative Liaison with Americans for Prosperity in Virginia. We thank you for watching today, and we hope you have a great evening.